This is an action to recover damages for personal injuries arising out of a motor vehicle accident involving a vehicle owned by the federal government and operated by the plaintiff, and a vehicle operated by the defendant, William R. Beach, and owned by the defendant, LRAC. The collision occurred on January 29, 1998, when Beach's vehicle struck the defendant's vehicle in the rear as he allegedly slowed and then stopped before making a left turn. Beach left the scene of the accident but was later apprehended and pleaded guilty to following too closely and leaving the scene of an accident. After the defendants answered, the plaintiff moved for summary judgment on the issue of liability, asserting that there was no non-negligent explanation for the rear-end collision. The plaintiff argued that both Beach and the driver and LRAC as the owner were liable for the accident. In opposition to the plaintiff's prima facie showing of her entitlement to judgment as a matter of law on the issue of liability, LRAC failed to raise a triable issue of fact. Contrary to LRAC's argument, the fact that the plaintiff stopped her vehicle before making the turn does not provide a non-negligent explanation for the collision, and it does not raise an issue of fact as to whether the plaintiff was negligent and whether such negligence was a proximate cause of the accident. C. Colon versus Cruz, 277, Appellate Division 2nd, 195, 2000. Sorrentino versus Reamer, 252, Appellate Division 2nd, 522, 1998. The Supreme Court properly granted summary judgment in favor of the plaintiff on the issue of liability. In a separate motion, the plaintiff moved to dismiss the first and second affirmative defenses asserted by LRAC in its answer. LRAC alleged that the plaintiff's action was barred by Article 51 of the insurance law because she did not sustain a serious injury and her basic economic loss did not exceed $50,000. The plaintiff argued that as a federal employee, she cannot collect no-fault benefits from the United States and therefore she cannot be considered a covered person under the no-fault laws. Therefore, the plaintiff argued that her action was not limited by Article 51 of the insurance law. The Supreme Court granted the motion. We modify and reinstate LRAC's first and second affirmative defenses. A covered person under the no-fault law, insofar as is relevant here, is defined as either the operator of a motor vehicle which is subject to the provisions of the no-fault laws through Vehicle and Traffic Law, Section 321, or any other person entitled to first-party benefits. A covered person is not defined solely by his or her ability to collect first-party benefits. Although the United States is exempted from furnishing security under the New York Motor Vehicle Financial Security Act, see Vehicle and Traffic Law, Section 321, it is subject to the provisions of the no-fault law, see Vehicle and Traffic Law, Section 321. Joyce versus Winkler, 71, Appellate Division 2nd, 28, 29, 30, 1979. Cole versus United States, 1986, WL 5805, 3, Southern District of New York, May 16, 1986. Liberty Mutual Insurance Company versus United States, 490, F Supplement, 328, 330, 1980. Thus, the plaintiffs in the instant action are covered persons by virtue of the fact that at the time of the accident, she was operating a motor vehicle owned by the United States, which is subject to the provisions of the no-fault laws, see Insurance Law, Section 5102. There is no merit to the plaintiff's argument that she cannot be considered a covered person since she is unable to collect first-party benefits from the United States. As a federal employee, the plaintiff's exclusive remedy as against her employer, the United States, for work-related injuries is the receipt of benefits afforded by the Federal Employees Compensation Act. Thereinafter, FECA, C5, United States Code, Section 8101, et sec. The plaintiff commenced this action seeking, inter alia, a declaration that the defendant, Liberty Mutual Insurance Company, thereinafter Liberty Mutual, is obligated to defend and, if necessary, indemnify it in an underlying action entitled Marrow versus TPK Construction Corporation. The Supreme Court, inter alia, granted that branch of the motion which was for summary judgment, and we affirm.